Yes, someone else
Oh,
is
there
working.
you are. There you are. Okay.
Good, good, good.
Go ahead. All right, Mr. Morag, good morning.
Let me open court, please.
Oh, I'm sorry. Go ahead.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-7162 et al. Wye Oak Technology, Inc. versus Republic of Iraq and Ministry of Defense for the Republic of Iraq appellants. Mr. Morag for the appellants, Mr. Katyal for the appellates.
All right, Mr. Morag, good morning.
Good morning, and apologies for the delay. May it please the court. I'd like to start with the subject matter jurisdiction issues, if I may.
Good.
This case is a single cause of action for breach of contract. That contract is the broker services agreement, which called for Wye Oak to refurbish military equipment, construct repair facilities, and decommission equipment for scrap sales, all in Iraq, all of Iraqi military equipment. It was negotiated in Iraq, signed in Iraq, and is governed by Iraqi law. And critically, Wye Oak was to invoice Iraq in Iraq and sought to be paid in Iraq. And it is that the breach of contract alleged in the complaint and found by the district court was the non-payment of invoices in Iraq. In light of that, the Fourth Circuit's ruling sustaining an immunity exception under Clause 2 of the Commercial Activities Exception cannot stand as law of the case after the Supreme Court's decision in OBB versus Sachs, and it was clearly wrong at the time it was issued in 2011 as well.
Mr. Morag, can I ask you a question?
Yes.
Are you suggesting that it would be law of the case if you agreed with the substance of the ruling? Do you concede that it's law of the case, but that you're saying these exceptions apply, that we shouldn't do law of the case because it isn't correct or because there's an intervening decision, but absent those, you would believe this to be law of the case?
Yes, Your Honor. As we lay out in our brief, and it's undisputed, I believe, the law of the case doctrine applies initially. The issue of intervening change in the law and a determination by this court that the Fourth Circuit's decision was clearly erroneous and created a manifest injustice are described in your case law as exceptions to the doctrine. We think both apply. And what that does is that permits you to reconsider the Fourth Circuit's decision. And when you do that, you would be applying the de novo standard of review.
Almost nothing else appearing, though. The Sachs decision from the Supreme Court clearly must be the controlling. Supreme Court precedent would control over law of the case, would it not?
Yes, it is. Yes, it would. And that's why the Supreme Court's decision is intervening
exactly.
Controlling authority.
Exactly.
What you've said in McKesson 2 was the standard to determine whether it affects your reliance on the Fourth Circuit's decision is whether it's material to the outcome. You would just look at the Fourth Circuit's decision today after Sachs and decide if it's still good law. We submit that you can only come to one conclusion on that question, and the answer is no. This court is very familiar with Sachs. You applied it only 2 months ago in the JAM versus IFC case to make this exact same determination on what conduct is a claim based upon. And here, the Fourth Circuit's decision cannot stand because the Fourth Circuit decided that this claim, this breach of contract claim, was based upon administrative tasks that Wye Oak performed in the United States in connection with the broker services agreement. But that cannot be the gravamen, the foundation, the core of the claim, because of two things that the Supreme Court reiterated in Sachs, which other circuits, including this one, had misunderstood before Sachs. And those are that the gravamen is the conduct that actually injured the plaintiff. And it's the conduct which, and therefore you have to look at what the plaintiff needs to show in order to prevail. Proving that Wye Oak conducted administrative tasks in the United States entitles it to no recovery from Iraq. Indeed, as Judge Lambert's lengthy opinion shows, the basis for Wye Oak's recovery in this case was proof that Iraq breached a contract to pay the pro forma invoices in Iraq, and then the attendant damages that Wye Oak suffered in Iraq.
So, Mr. Morag, I'm more concerned, I think, about sort of other issues related to law of the case, one of which is the peculiar circumstance of the Fourth Circuit having decided this to begin with. And what I'm trying to understand is, why shouldn't your client be made to live with the consequence of its decision to appeal the Fourth Circuit's decision, notwithstanding the fact that the case had been transferred? Seems to me you bore the risk that the Fourth Circuit would rule against you because you sought to appeal rather than just go with the fact that the case had been transferred and work through the system at the DDC and now this court. So we're in a sort of peculiar situation in which you're suggesting that a Fourth Circuit opinion on a legal issue somehow binds us in this context.
Well, Your Honor, the case law is clear, and the Christensen case in the Supreme Court was a situation where you had the Federal Circuit decision being considered law of the case relative to the Seventh Circuit. We would be in the exact same position if Wye Oak had filed this case in the district court in Washington. The district judge had rendered the same decision as the Virginia judge. We would have taken an interlocutory appeal, and you would have rendered the same decision as the Fourth Circuit.
Well, let me ask you, can I test that hypothetical? Because that's another sort of odd aspect in terms of your initial concession that law of the case applies. My understanding is that the Fourth Circuit ruled on a motion to dismiss, that they were determining whether the complaint contains sufficient allegations, if true, to sustain a claim against the defense of immunity. And they affirmed the district court judge that you did not have immunity, but on the complaint at the motion to dismiss stage. Suppose there was no transfer, the Fourth Circuit's decision stands. Is it your position that the district judge in the Eastern District of Virginia would not have been able to revisit the immunity decision during or after trial?
Your Honor, the answer is that the reason we said what we said in our appeal brief is because there's a decision by Judge Roberts in this court that explains that what happens when you make a motion to dismiss on sovereign immunity grounds at the outset is the court looks at the complaint allegations and makes an initial determination whether they state a immunity exception. The Fourth Circuit said they did. At trial, we were not able to, because they're not really disputed, to contradict the factual allegation that Wye Oak did perform some administrative tasks in the United States. That was not a factual dispute.
Right, but I'm asking you a different question. I'm asking you whether the law of the case doctrine would prevent the district court from revisiting that determination at a later stage in the litigation, regardless of whether or not they would have agreed with you on if you'd re-raise the immunity question. I want to know whether the Fourth Circuit's decision would be law of the case on the Eastern District of Virginia on that issue.
Yes, it would, and as well as the mandate rule. And the mandate rule applied to Judge Lambert as well, because the Fourth Circuit is an appellate court in the federal system, The transfer did not change the relationship between the appellate court and the district court in terms of the Fourth Circuit's decision.
But
Everything-
isn't the Fourth Circuit's decision only about the motion to dismiss? I would understand if Judge Lamberth were asked as soon as it came to him, you refiled a motion to dismiss and you made the same arguments. Then I see law of the case. What I don't understand is why, if a district judge is asked at a later stage of the case about immunity, again, the Fourth Circuit's opinion on immunity precludes that.
The Fourth Circuit's opinion itself discusses that it would be law of the case, notwithstanding the transfer. It's the majority decided it would be. The point is that the Fourth Circuit decided based on a factual assumption, it accepted as true one fact, that Wye Oak performed administrative tasks in the United States. The only way the district court, within the rubric of your question about the motion to dismiss, could have come out differently is if it found those facts not met. What we are saying is that the facts were established, but they still do not, as a matter of law, satisfy Wye Oak's burden of pleading an exception to the immunity of Iraq, which Iraq invoked and re-invoked after the Fourth Circuit's decision came down in its answer. It has preserved the issue, and you are the right court to decide whether, either because of intervening Supreme Court authority or the Fourth Circuit's decision itself at the time was clearly in error. There is no.
Well, we don't need to do anything about the Fourth Circuit's error or non-error if we agree with you that Sachs states the law governing this case and Sachs intervened since the original Fourth Circuit decision. Then the Fourth Circuit decision is no longer binding as law of the case, even to the extent the law of the case is usually binding.
Absolutely, Your Honor,
Okay.
That's correct. And that is why it appears that Wye Oak is looking for alternative grounds to substantiate the court's jurisdiction and has not identified those either that comply with the FSIA. The waiver argument that they raise is without basis because there was no because Iraq preserved the issue of its sovereign immunity. It certainly did not unambiguously, unmistakably, through any conduct post the appeal, affirmatively waive and indicate to the court and to Wye Oak that it was no longer contesting immunity and was conceding the court's jurisdiction, as your precedents would require a finding under the implied waiver exception under.
What about direct effects, Mr. Morig? What about direct effects? We have this other clause, even if we agree with you that based upon means based upon the gravamen of the suit. The gravamen of the suit is the breach. They also argue that the breach has caused direct effects in the United States. Why is that wrong?
Okay, well, first of all, on that, there is no law of the case issue. It's a de novo, it would be de novo consideration of an issue the district court never even decided. So the direct effects fail for the same reasons that they failed in any number of cases. The direct effects are not direct and were not felt in the United States.
But if the district court didn't decide it, why wouldn't we just send it back for district court consideration in the first instance?
Well, it was fully briefed before the district court and it chose not to, for the same reason the Fourth Circuit chose not to. These are issues that this court can resolve on its own. It does that. It did that in Bell Helicopter versus Textron. You just look at the allegation and it's a legal question whether that
direct effects is a legal question, not a question of fact as to what happened in terms of what's going on in the United States?
When the facts are not disputed, it's a legal question of whether the facts alleged satisfy the test of being a direct consequence of the sovereign's breach.
But we're beyond allegation. We had a trial, and my question is, why wouldn't we let the district court look at the record and determine based on his understanding of what happened at trial, whether there were direct effects in the United States.
Your Honor, that is an option you have, but I think when you look at what is alleged as a direct effect, you essentially have considered these types of arguments in other cases and have affirmed that they are not direct effects.
How about McKesson? Why is this case not closer to McKesson than it is to Zydan? It isn't just the payment of money. You had the operation running from somewhere in Pennsylvania. You had the folks who were doing all this scrap stuff over there of necessity, but it was being run from Pennsylvania.
Because, Your Honor, McKesson involves a situation where the plaintiff was a investor. It owned part of the plant that was expropriated. This is simply a contractor a U.S. contractor who had some of its employees in the United States and was performing administrative functions here. It is not, there was no intended performance from the United States. This wasn't a contract to supply U.S. goods or anything like that. It was a contract with that the only connection is a U.S. Contractor who by necessity had employees and operations in the United States.
Well, yeah, but these people who were doing all this scrap work over in Iraq, they had to get their directions from the people in Pennsylvania. That is, what to scrap, what not to scrap, and so forth. They were basically, if you had the contractor analogy, they were the people in Pennsylvania were the contractor, and the folks in Iraq were the subs or the carpenters and so forth. I don't see why this doesn't have a direct effect and why we shouldn't send it back. I think Judge Lamberth was wrong on the commercial activity, but this is a vast record. He can take another look at it under the third clause and reach his decision.
Well, Your Honor, if I'm permitted to respond, I think that what you describe is true of every U.S. contractor case and not distinguishable. The decisions about what to scrap, what to refurbish, were all to be made in Iraq between Wye Oak's personnel there and the Iraqi Ministry of Defense and the U.S. authorities. This is not a situation any different from the many cases which involve no obligation of payment in the United States and no anticipated performance in the United States. This is really Helmrich and Payne, which you more recently ruled on, and there is no McKesson connection because of the absence of any interest in any business in Iraq, which is what
about the potential interference with the other contracts that they were trying to make in the United States? I thought there was some allegation or evidence of a relationship with other businesses that was interfered with precisely because the Wye Oak said we haven't been paid yet for these invoices and the like.
Yes, Your Honor, and Judge Lamberth made an explicit finding that the subcontract with CLI, which was the company that was supposed to do the construction work, had not been signed, had not been entered into. And that was a factor that this court in Helmrich and Payne specifically relied upon as to why, therefore, any effect on subcontractors was not a direct effect, because there were
not an effect on subcontractors, right? They didn't have the contract yet. I'm talking about an effect on Wye Oak. We have a tort that is interference with business relationship, right? That's a well-established thing that if you're developing a business relationship with someone and another person comes along and interferes with that, that's a harm. So what I'm asking is, why isn't it the case that Wye Oak was affected in the United States by the alleged interference with its relationship with CLI because of the breach?
Your Honor, that is a theory that Wye Oak has never pleaded, not before the district court, not before this court. There is no tortious interference. First of all, Iraq breached a contract. There is no tort claim against Iraq in this case.
I'm not saying they have to make the elements of a claim, because all we're doing is looking for direct effects. And I'm just suggesting that it's no answer to say, but they didn't have a contract with these other people. Exactly. They didn't have a contract, they say, because Iraq breached the agreement. And so why isn't that a direct effect? We were on the verge of making a contract, and we weren't able to do it because of the breach. And the contract we would have had was in the United States. Why does that not count as direct effect?
Because that was the precise argument raised in Helmrich and Payne, that the Helmrich and Payne would have entered into the subcontract but for Venezuela's breach. And that didn't work there. What worked in Carnival Cruise Line was a situation where the subcontracts were an integral part of, and Canada was, the contract clearly contemplated these US subcontracts. And so that was considered a direct effect. But absent the actual contract, there is no direct effect, because it just doesn't count. It's not direct, and there's an attenuation that this court has said breaks the causal chain.
All right.
All right, if there are no more questions, then we'll hear from you, Mr. Katyal.
Thank you, Judge Henderson, and may it please the court, Neil Katyal for Wye Oak. As General Petraeus testified, Wye Oak and Iraq entered into a commercial contract with massive military and diplomatic importance, but Iraq refused to pay what it owed, and Wye Oak's CEO was brutally murdered while he was trying to collect that payment. Now, before this court, Iraq doesn't dispute it breached the contract, nor does it dispute that Wye Oak suffered damages. Yet Iraq is saying it should pay nothing, and that's wrong. On jurisdiction, they must overcome 4 independent bases: waiver, law of the case, the merits of the second clause, and the merits of the third clause. So Judge Henderson, even if you think the merits of the second clause cut against us, there's still 3 independent things they'd have to run the table on. Now,
Why don't you concentrate on the third clause?
Sure. So I think what you just heard my friend say on the other side about the third clause is that we never argued anything about CLI and the withdrawal. No, absolutely. We isolated 4 different direct effects in our briefing below.
Yeah,
By the way,
I know it's Judge Henderson's question. I'm going to say, enumerate those 4 direct effects, please.
absolutely. The first was payment to a United States bank, which we designated. The second
isn't that something that would be normally appearing in contracts between the United States entity and a foreign sovereign, so that you're writing the direct out of the statutory exception, aren't you, if you say that's enough?
No, Your Honor. I think direct just refers to, is there any sort of intervening cause? Here, the contract itself with the sovereign gave Wye Oak the ability to pick the place of payment, just as actually the contract in Weltover did. And there's no intervening cause. Wye Oak, under the agreement that Iraq signed, agreed to use the Pennsylvania bank. And so that is a direct effect. Now, I know you might not feel it's substantial, but the Supreme Court in Weltover said that's not the test anymore. So that's the first direct effect. The second is the one I was referring to with Judge Henderson, the cutoff of capital and personnel. And we litigated this below, and they put in zilch, not a word, which is why we think they've waived all of these sovereign immunity arguments, not just on clause 2, but on clause 3 as well. We argued, and this is at Joint Appendix page 573, something the district court found, that because Iraq breached the contract, that cratered the agreement with CLI. We had a verbal agreement, they were performing under the agreement, but they needed a guarantee of financing. And that's certainly enough, as Judge Henderson, you were talking about with McKesson, enough to qualify as a direct effect. The third direct effect, and this is one I understand some members of the panel have disagreed on at various points, is the targeting of a US corporation. Our argument here below was that Iraq specifically targeted a US company it knew would feel the loss in the United States. Wye Oak isn't some random company. They were handpicked by the US military and the intelligence community to do this kind of work, this very specialized work.
Targeting by whom, though, Mr. Katyal? Targeting by whom?
targeted by Iraq for breaching this agreement. So Iraq knew that by breaching the agreement, it would cause pain in the United States. The agreement itself recites that Wye Oak is a United States company. And the disagreement that two members of this panel had in EIG was about whether or not there are intervening causes at issue in that case. Here, there are no intervening causes. Iraq breaches the agreement. That directly harms a United States company.
But what
I'm
is
not
the
sure that's
evidence?
all of our disagreement, but perhaps it's at least part of it.
What is the evidence that it was the Iraq's intention to target this company? I mean, it just seems circumstantial that it happened to be a U.S. company, but where's the evidence in the record of actual maliciousness in terms of targeting of a U.S. company?
Again, I don't think it needs maliciousness, Judge Jackson. I don't think that's a test. It just requires targeting. And here, Iraq knew that Wye Oak was a United States company and performing a critical mission. The agreement itself recites just how critical this mission is to the United States and to Iraq. It's critical to, for example, the withdrawal of United States forces. General Petraeus and the testimony referred to by the district court on this, I think, is very telling. So
I thought your targeting argument was more about this Zena or whatever, more of a fraud argument, that Zena was a crook all along.
That's part of it, Your Honor, but it isn't the only part of it. It's also just the cutoff of funds that withdrew, the refusal to pay a huge bill to a United States company. And then the fourth point is the diplomatic effects and all of the stuff that we isolate, the immediate consequences of geopolitical effects that by withdrawing from this contract, it had massive impact on United States personnel, United States foreign policy, and the like. And our most important point to you,
does the current record really bear that out, and what's your position as to whether or not we should send it back so that Judge Lamberth can take a look at that?
Absolutely, Judge Jackson. They don't get another bite at the apple. I mean, we litigated this for pages and pages, even though sovereign immunity is their burden. And I think this court, Judge Sentelle, your opinion in Belize Social Development, and the court's opinion in Al Haddad says, they bear the burden of proof. And if the evidence is in equipoise at all, you give the doubt against sovereign immunity. Here, they made zilch of an argument in the district court. And Judge Jackson, this brings me to the law of the case argument or waiver arguments. I think however you want to phrase it, as this case came to the district court, they picked the Fourth Circuit. They said the Fourth Circuit decisions would control. You even heard my friend again today say something very similar. And now in the district court, what do they say? They give you a whopping they give the district court a whopping one sentence on sovereign immunity with respect to everything, clause 2 and 3. And that is at Joint Appendix page 505, quote, "The court shall determine its jurisdiction accordingly."
But Mr. Kutyal, can I just tell you that I sense some tension in your argument on this point, to the extent that the Fourth Circuit's argument or decision was law of the case, which I am struggling to see, but assuming that it is, then how is it that Iraq can be faulted for not seeking to revisit that vigorously once the case was transferred? It seems as though everybody agreed that the Fourth Circuit had bound them with respect to this issue. So I don't know that we can suddenly say, well, because they didn't re-raise it and have a whole long brief about it, that they now have somehow waived it.
So Judge Jackson, this is a sovereign immunity, both clause 2 and 3 is a fact-specific determination. And here we made all of these arguments about the facts and so on. All they didn't even make the argument that they're sovereign immune. They just said determine jurisdiction accordingly, and they bear the burden of proof. Now I heard my friend say on the other side, yeah, we're just contesting the law, not the facts. I think that's exactly what the law of the case doctrine forbids. And as you said, they should assume the risk, having agreed in the Fourth Circuit to one set of rules, to not be able to challenge it again. And Judge Sentelle, you said, well, what if the Supreme Court makes a different change in law? That's binding. We absolutely agree with that. The problem for them here is that that change in law has to be material. That's what this court's decision in McKesson said. Judge Henderson, you were on that panel. And our point to you is that the Sachs decision it's not about contract, breaches of contract, which are very different for the reasons our brief explains. It's a clause 1 case, not a clause 2 case. And, at the very least, we think for whether you want to call it waiver or law of the case, they should have made some argument about Sachs below. Everything you just heard my friend say in his 18, 19 minutes was something that the
I don't
district
see
court
why
was
the
never-
gravamen question would be any difference in clause 1 and clause 2. See, I fail to see why Sachs isn't a material decision.
Well, I think the Supreme Court itself, Judge Sentelle, went out of its way in Sachs to say in footnote 1, they're only deciding clause 1, that there's a lot of unique aspects to each of these clauses. And so I at least don't think it's a controlling change.
I don't
in the
see how
law.
they could consistently come out differently on clause 2. If
I
you
think-
read, if you read the Chief Justice's reasoning on in Sachs.
I very much think, Judge Sentelle, they could because of the difference in the language, because clause 1 refers to a commercial activity by the foreign state. Clause 2 is a bit looser. It's an act performed in the United States in connection with a commercial activity.
Yes, Mr. Katyal, but the treatise that you all cite in your brief, which I happen to look up, makes it very clear. This is the Sanchez treatise, makes it very clear that clause 2 also applies to the defendant's conduct.
Yeah.
That it's
Yes.
an act of the defendant. That's what the
Yes.
whole thing is about.
Yes.
So I don't understand how anybody could think that the Fourth Circuit's interpretation of it, an act of the plaintiff, could be correct.
Judge Jackson, we're not arguing that that isn't a way to satisfy clause
Okay.
2, but nothing in that treatise says it's the only way. And there's a really important textual point that we make in our brief, because clause 2 refers to a foreign state. This is at our addendum to the brief at page 3, which reproduces it. A foreign state shall not be immune from the jurisdiction of courts in any case in which the action is based upon an act performed in the United States in connection with commercial activity elsewhere. The clause there doesn't specify who must perform the act in the United States, whereas clauses 1 and 3 do exactly that. Now, to be sure, there just aren't that many clause 2 cases, but that's because any case in which there is foreign sovereign activity in the United States already meets clause 1 and sometimes meets clause 3. So that's why you just don't have precedent on it, but they don't have a case the other way saying that this wouldn't satisfy it.
Can I just ask you, Mr. Katyal, to entertain my hypothetical with Mr. Morg, because I fear that I don't understand law of the case. It seems to me that the Fourth Circuit, to the extent that law of the case is deciding the same issue in the same way or whatever, that it's a different issue when immunity is raised during or after trial than it is when immunity is raised testing the allegations of the complaint. Mr. Morg says, oh, yes, I see that, but we don't have any reason to think that the facts were in fact different after trial with respect to prong 2, which is why we didn't raise it. And why I'm asking whether the district judge was precluded from taking another look at it because of the Fourth Circuit's opinion, setting aside transfer. So my hypothetical assumes we don't have a transfer. The Fourth Circuit says what it says, and then we have a trial, and then Iraq hypothetically says we are immune, district judge. Is law of the case preventing the district judge from deciding that at that point?
So setting aside waiver, which I think is a separate problem, but just if this were raised somehow to the district court, I think this court's decision in Shirley versus Sebelius back in 2012, and Judges Sentelle and Henderson were on that decision, I think answers that, Judge Jackson, by saying ordinarily law of the case would apply, so long as you had a fulsome legal adjudication and there isn't some massive change in the facts. Here, my friend on the other side is conceding after this long trial, no change in the facts. So now the only question is this a material intervening decision in Sachs? And look, I can imagine some arguments for why it is. I'm not saying it's impossible, but boy, as a matter of prudence and fairness to the district court and to us, that should have been an argument that was made in the district court. They never breathed the word Sachs there. They never breathed the word Nelson, the predecessor case in the Fourth Circuit. So they go and they brief all of this sovereign immunity extensively in the Fourth Circuit. And when it comes to DC, what do they say? That one sentence I gave you, nothing more. And now here we are all litigating, having to try and figure out whether or not Sachs applied, how it changed the law, and so on. There's no precedent for this court going and jumping past waiver and law of the case on something like this. And, you know, this has real world
And
consequences.
you're
Real
linking
world.
waiver and law of the case. They're not in the same posture here, are they, Mr. Catchell?
They're two very separate arguments, Your Honor,
Yes.
but they both paint in the same exact direction, which is law of the case. I think, as Judge Jackson said, look, they agreed to the
Are you
Fourth
still, are
Circuit.
you still willing to say that they come together if one of us at least, and maybe more, would be convinced that waiver is not present?
Oh, the law of case would still absolutely be.
Okay, I
present.
think you
Yes,
have, yeah, I think
absolutely.
you want to delink those.
Excuse me, sorry, I couldn't hear that.
You want to delink them.
It's
Yeah.
exactly. I want to, they are two
Delink,
separate
delink,
arguments,
yeah.
as I said, Your Honor, at the outset. And we certainly think clause 3 is a separate argument as well and requires no remand. They had their bite at the apple to argue all of the direct effects in the district court. They said nada about it. And it's totally unfair now, after we've expended huge amounts in a trial, to say, oh, we now have some clause 3 arguments. That time to do that was at the trial. The district court found these facts.
Can I just ask you a question? You keep saying we spent all this time, Wye Oak, on this issue before the district court, and they said nothing. I'm still wondering why you're spending time on it if that's their burden, and if law of the case, the Fourth Circuit has already said there's no immunity.
Right.
Were you
Because-
trying to prove to the district court something that you didn't have to because law of the case already took care of it?
100%, Your Honor. It's always their burden, but we, as a matter of belt and suspenders, wanted to be absolutely prudent. As you can imagine, this is one of the most important, this is the most important thing Wye Oak has ever faced. And so, as a matter of careful lawyering, we did that. But we certainly don't think the fact that we developed a record, made all of these arguments, and the district court found them all, including the facts on clause 3 in our favor, should somehow hurt us and penalize us and mean that they get to reopen things. We've been clear from the very start, from the time this case was in the EDVA, what our arguments have been. Their arguments have shifted, morphed, and changed over time to the point where here we are now, almost 2 decades later, having to litigate some of this stuff that was once upon a time litigated in the Fourth Circuit, but definitely not litigated below in the district court. And, you know, so they bear the ultimate burden here. I think that's what the precedents of the DC Circuit have said time and again.
If there are no more questions, Mr. Cottrell, I know we told you that you would have 2 minutes on damages, but I'd like to amend that and say if neither of my colleagues has any questions about the damages, we'd like to take that on the briefs.
No questions.
Judge Jackson.
No questions. Thank you.
All right.
And Judge Henderson, on the cross appeal about the 2 complementary compensation things, is that included in the question?
Yes.
Your colleagues?
Yes. All right. So Mr. Morak, why don't you take 2 minutes?
Okay, thank you, Your Honor. I just want to make one point on the burden of proof. What you said in Bell Helicopter and what Wye Oak actually acknowledged itself in its proposed findings of fact was that it had the burden to articulate an FSIA exception that worked on the facts it alleged. And in Bell Helicopter, what you held was the district court did not err in ruling that Bell failed to meet its initial burden. And that even though it had articulated all of these direct effects that it believed occurred in the United States, and you held that because you decided they did not qualify as direct effects. That's the argument we're making. They haven't come forward with a theory of an exception that is legally plausible and that would survive if we said nothing else after that.
Mr. Katyal says that not only have they done that, but that you all said nothing before the district court as they tried. Is that true? And why shouldn't we consider your argument with respect to this, therefore somehow waived about the argument that they haven't done enough?
Your Honor, the issue is unique to subject matter jurisdiction. In the Prince versus Germany case in which Judge Sentelle you sat, Germany had raised an argument for the first time on appeal against the district court's subject matter jurisdiction. And this court held that you would consider that belated argument if it were of any consequence to the jurisdictional determination because of the unique fact that subject matter jurisdiction cannot be created by consent, waiver, or estoppel.
Yeah.
That is simply a rule that applies here. There is no forfeiture. of arguments that can be possible as long as you accept that we preserve the issue of sovereign immunity. And we did that because there was no unmistakable and unambiguous waiver of that point to satisfy the FSIA. Nelson was cited to the Fourth Circuit. Nelson was cited by the Fourth Circuit. With respect to Sachs not being relevant to Clause 2, this court in Odiambo recognized that structurally the based upon phrase applies to all three categories of the commercial activities exception. You applied it again 2 months ago in JAM versus IFC. You considered the clauses 1 and 2 in tandem in doing your based upon analysis. So I think that one's clear. With respect to this issue about no case establishes that the plaintiff's conduct can't be for purposes of Clause 2, we cited the AAA case. It's in the briefs. It's out of the Sixth Circuit. That's exactly what it holds on this similar record of a U.S. contractor seeking to predicate jurisdiction on its U.S. activities, administrative activities. On the issue of the payment from the request for payment, Judge Sentelle, you were exactly right. The demand for the payment to the account in the United States was sent by Wye Oak to Zaina. There is no evidence whatsoever that that was communicated to Iraq. Iraq agreed to make payments in Iraq at the Office of the Ministry of Defense in Baghdad. So that doesn't count because it's not, as you said, something between the sovereign defendant and the plaintiff.
All right, Mr. Morag, you need to wind it up.
In that case, those are the points and
all
we
right.
rest on our briefs
Thank
on the
you.
other issues.
All right. Thank you, gentlemen. And Madam Clerk, if you'd call the next case.
Case number 21-7008, Schindler Elevator Corporation, a New Jersey corporation, appellant, versus Washington Metropolitan Area Transit Authority, an interstate agency created by Compact & Coney, Inc. Mr. Bartolomucci for the appellant, Mr. Barnes for the appellees.
Mr. Bartolomucci, go ahead.
May it please the court, Chris Bartolomucci for appellant Schindler Elevator Corporation. This must be the court's day to hear waiver cases. Our position in this case is very straightforward. WMATA has waived its immunity in protest cases like this one. In the Procurement Procedures Manual, WMATA adopted a clear protest policy, which states that federal district courts, quote, have jurisdiction over court actions concerning protest decisions, end quote. The policy requires WMATA to give notice in all solicitations. WMATA's policy is to tell protesters that they can go to federal court. WMATA did so in the RFP here and in the final decision denying Schindler's protest. Now, WMATA—
Mr. Bartolomucci, can I just ask you a basic question? Because your argument does sound very straightforward, but I'm trying to understand how you can argue that WMATA has the authority to waive its immunity, that WMATA itself can come up with the conditions under which it can be sued in light of the compact, which gave it immunity on certain conditions.
Well, Your Honor, the immunity belongs to WMATA, and WMATA therefore has the power to waive it.
But WMATA didn't get all immunity. WMATA didn't get a whole, if you will, of immunity. WMATA got immunity under certain conditions, right? Am I wrong about that? I thought the compact says you get this immunity and you can only be sued for contracts and torts related to your proprietary functions. So under what circumstance does WMATA get to say, no, we'd like to be sued under other things, for whatever we put in our manuals? Do they have the ability to do that?
They certainly have the ability to waive their immunity. Sovereign immunity may be waived at pleasure. And I
But they
would
didn't,
point,
but they're not a sovereign. They got their sovereign immunity from somewhere else. And so do we have any cases that say that WMATA has the authority of a true sovereign in terms of its ability to waive its immunity outside of the circumstances of the compact?
well, yes, let me cite you two cases. So in the Barber case, this court held, I know that Judge Sentelle dissented, but not on this ground. In the Barber case, this court held that WMATA waived its immunity by taking federal funds. Now, it wasn't the three states that took the federal funds, it was WMATA, and that was held to be a waiver. And in the ongoing unsucked DC Metro case, so that's a case in which WMATA has created a FOIA-like cause of action. And there's an issue about whether it can do that, but there's no issue about their ability to waive their sovereign immunity in that case. Obviously, they can't create a FOIA-like action unless they waive their immunity against such claims. And that's not even an issue in that case. The issue that's being litigated is whether they can create a cause of action in the first instance, but no one has disputed that they can waive their immunity to entertain such claims if they can validly create a cause of action. So I think there's no doubt, Judge Jackson, that they can waive their immunity. And the only question,
I think there is a doubt. And can you just entertain it's a doubt that maybe is only mine and that I'm creating in this context, but the compact, what gave them the immunity, carried with it certain conditions. You are immune to all of these various things except for torts of certain types and contracts. I don't see anywhere in that compact that also said, and any place, any time that you decide that you would like to be sued, any waiver that you would come up with. So under what circumstance, I'm trying to understand, does WMATA get to say, we see the compact and the circumstances under which the states wanted us to be sued, but we're going to decide that we can be sued in other situations?
okay, I'm glad you asked that question, because this gets to Section 80 of the compact. Now, Section 80 waives immunity for contract claims and for certain tort claims, but Section 80 is not the end all and be all. WMATA has the ability to waive other claims in other ways, just like it did in Barber. Barber did not involve a contract or a tort claim. It involved a Section 504 Rehabilitation Act claim for termination based upon mental illness. But this court held that because WMATA accepted federal funds, it waived its immunity. In the Slack case in the district court, that involves a statutory whistleblower claim. So not a contract or a tort claim. And the district court held in that case, and WMATA didn't appeal, that WMATA's adoption of a policy telling whistleblowers that they can sue effectively waived their sovereign immunity as against these whistleblower type claims. And again, I will again cite the unsucked DC Metro case. That involves a FOIA-like claim. It's not a contract claim. It's not a tort claim. So it's not governed by Section 80. But there's no dispute in that case. And I think my friend on the other side will say this. WMATA has the authority to waive its immunity as against a FOIA type claim, what they call a PARP claim. So Section 80 governs some types of waivers, but it's not all encompassing. Otherwise, Barber would have been very simple. Barber would have said, well, this isn't a contract or a tort claim, so Section 80 doesn't apply, and you're out of luck. WMATA has immunity, but this court held there was waiver in Barber, and Judge Sentelle's dissent was on other grounds. So I really do feel that because the cases are legion, saying that sovereign immunity is the kind of immunity that can be waived at pleasure. If they never raise it in a case, and if the district judge doesn't bring it up, it's gone. If they remove a case from state to federal court, it's gone. So it can be waived in lots of ways. It's not all governed by Section 80. So if you accept my premise that sovereign immunity is waivable, I think they've clearly done that in the PPM, the Procurement Procedures Manual, and they did it again in the RFP and in the final decision on Schindler's protest. You know, I understand that there is an issue in this case about whether WMATA is a federal agency or not. But what I would say about that is that's not a jurisdictional issue. That goes to what Schindler's cause of action is. And, you know, we're not here today on a 12B6 motion. We're not trying to decide whether Schindler can state a cause of action. Schindler got bounced based on sovereign immunity. So I think it would be unfair to.
So your case today does not depend on being a federal agency, WMATA being a federal agency, I mean.
That is correct. And the court doesn't have to answer that question. If WMATA is a federal agency. That's what I'm getting at, yeah. Yeah, and Judge Sentelle, you faced this issue in the Elcon case, and the panel that you wrote for decided not to decide that issue because it's trickier than you might think. But if WMATA is a federal agency, then the federal APA applies, and they've lost immunity.
You maybe don't want to get into all of that.
I won't. The court doesn't have to.
Mr. Bartolomucci, let me go back a little bit to the question that I asked you in another way, which is so is it your argument that Section 81 of the compact that talks about the jurisdiction of the courts has to be interpreted separate and apart from 80? And if so, what do we do about our precedents that say those two are working in conjunction with one another?
Well, here's how I read it. Section 80 broadly gives the federal courts jurisdiction. Now, sovereign
81,
immunity.
I'm sorry, 81 is what you meant?
81, yes.
Yes.
I'm sorry. 81 gives the federal courts jurisdiction. Now, sovereign immunity is a defense to jurisdiction. Sovereign immunity is partially waived in Section 80, but it can be waived in other ways as well. So you can have a case like this one where jurisdiction arises under Section 81. The case is not governed by Section 80, and WMATA has effected a waiver in another way, in this case by enacting a clear protest policy.
I was going to say you would have to concede that the waiver has to be clear.
It does.
Right.
That's the Barber test.
That's yes.
But don't we have precedent from this circuit? And I can't remember the case name off the top of my head, but don't we have precedent that says that you interpret 81 consistent with 80?
Well, the court has said things like that in cases involving tort or contract claims, which is the vast majority of claims against WMATA. But this is this is an administrative APA type claim. So you have to pay attention to whether the cases that say things like that involve tort or contract claims, which this case does not. So that's why 80 doesn't apply here, because this is an APA or an APA-like case.
All right, if there are no more questions, Mr. Barnes. Mr. Barnes.
Thank you, Your Honor. The court should affirm dismissal because the WMATA compact that was adopted by the three jurisdictions establishes WMATA's sovereign immunity in this case. As the court noted in the Banneker decision, Section 80 provides that there's only a limited waiver of claims in Section 80, and that's for contracts and certain torts. In this case, Schindler has conceded that this case does not involve a contract or tort. It's Schindler's burden to prove jurisdiction, and it hasn't done so. This is a jurisdictional issue, and this court has been clear, both in the Kiska case and in the Burkhart case, that this is a subject matter jurisdiction issue, the sovereign immunity of WMATA.
Can you entertain Mr. Bartolomucci's framing, though? Because what he is suggesting is that the statement in 80 concerning contracts and torts actually relates to those kinds of claims, but not necessarily the scope of the immunity. In other words, he says, fine, this is not a contract or tort claim, so 80 doesn't apply, and 81 says the court has jurisdiction, and WMATA has all of the sovereign immunity of the original states that created it. Why is he wrong about that?
Well, he's wrong because the courts have decided otherwise. And in the Morris case, there was certainly, as Your Honor was discussing earlier, you need to read these in conjunction. And Section 80 has been interpreted and found to be the limited waiver clause. And Section 81 is found to be basically the forum selection type clause. In other words, you can't read them separately. You have to read them together.
So is it your position that the states that created WMATA gave WMATA the full immunity and per the compact waived only what we see in 80? So every WMATA cannot be sued for anything else.
That's correct. And it's very clear when you look at the cases that were cited, both FAA Cooper and there's a subsequent case, the Sossaman versus Texas case, that it must be very clearly and unequivocally stated in the text of the statute. So whether it's a federal agency or a state agency, the rule is the same. WMATA in this case is an instrumentality of the states, and that's undisputed in this jurisdiction.
Okay.
But it's still,
if it's possible, I know you don't think it is, but if it's possible for WMATA to waive its immunity, what do you say to the manual as a source of waiver?
well, the manual is not except for the policy statement. And I know Mr. Bartolomucci was careful in his statement about policy. The project procedures, the project procedures manual is not a policy statement except for the portion that relates to the policy adopted by the board. So the procedures manual, as all the provisions that are cited by Schindler, were not adopted by the board. This is procurement staff making statements. And same with the RFP and with the contracting officer's final decisions. These are not approved by the board, and they are therefore not actions by the board. So at most, you would have a situation where the board could take some action. But even then, you would have to have some sort of statutory text according to the case law, both FAA versus Cooper and Sossaman. So I think it's
I'm sorry, some sort of statutory text that gave WMATA the right to waive?
Statutory text. The only way that there can be any change in Section 80's limited waiver of sovereign immunity is if it were somewhere else in statutory text, and it is not in statutory text. And I think Mr. Schindler would like this court to make some new law that WMATA can decide whenever it wants to waive immunity. That's not the case. And the only example that my friend on the other side is making is that in those situations where Congress specifically requires that in order to receive funds, you have to waive immunity, those situations are completely different than the current situation. If in the Barber case involved receipt of federal funds, as well as the Slack case, a district court case. But those are the only two cases that my friend on the other side can cite. But the overwhelming authority is that any waiver must be in statutory text. And when you look at Section 80 and read it in combination with Section 81, as this court has said we must do, there is only waiver for contracts in certain torts. So
can I ask you in terms of the clarity, because I'm very interested in Mr. Bartolomucci's framing of the compact. We don't see a statement in that document in 80 or in 81, I think, that says the authority shall only be liable for its contracts and for its torts. The authority is not liable for anything else. The states are waiving their immunity only for these particular kinds of claims. It just announces that the authority shall be liable for those. Mr. Bartolomucci says, fine, but there's nothing in here that says that the authority shall not be liable for the kind of claim that I'm making. Why is he wrong about that?
Because the full sentence says the authority shall be liable for its contracts and its torts committed in the conduct, but shall not be liable for any torts occurring in the performance of a governmental function. The exclusive remedy for such breach or of contracts or torts for which the authority shall be liable shall be a suit against the authority. So it does provide that that's the exclusive remedy And that would have
No,
to subsume the
the
contract. of course.
exclusive remedy for the claims they're talking about in that paragraph. I don't see anything in that paragraph that tells me that the authority could not be liable for something else. Right?
Well,
They just
then-
want to make clear that the authority is liable for these things, but why does that necessarily mean that the authority is immune from procurement or other kinds of claims?
Well, that's what's been decided by this circuit in the past, including in the Morris case. So this statute, as it's been written, the compact as it's been written and applied in this jurisdiction, is that the exclusive, the scope of the waiver is only for contract claims and certain torts. So we would be making new law here to the extent we contradict the prior decisions of this court, and that's the precedent of this court. But in Your Honor, there would have been no reason to include the language that's in this section 80 had WMATA been responsible or not liable or not immune from any actions.
Except to the extent that this paragraph is doing the work of explaining that quirky thing about torts, right? I mean, you could imagine a world in which if they didn't care about certain torts versus other torts, they wouldn't have said anything and WMATA would be liable for it all. But
Well,
this paragraph is about just making clear that only certain torts, maybe. I'm just hypothesizing.
Then there would have been no reason to include contracts under your theory.
Fair point.
So Your Honor, I know that there was a reference to the Unsuck case, and I'm happy to answer any questions that you have about that. Certainly the DC Circuit, when it was hearing the Unsuck case, was skeptical about the issues in that case. I do disagree with my opponent that it is a matter that WMATA can therefore do whatever it wants with respect to waiver. In that case, and certainly the record that my friend on the other side has put before the court showed 67 pages of board resolutions after notice and comment. That is very different than the situation here, where procurement staff members are issuing a procedures manual or a contracting officer's final decision that is not approved by the board. And there has been no decision, obviously, in that Unsuck case. But the fact that Section 73 of this compact deals with procurements and protest decisions, and there was no judicial review provided, certainly the jurisdictions knew how to provide for a remedy, and they did not do so as they have done in other statutes. And that is.
I'm sorry, can I ask you a slightly different question? That stems from Judge Sentelle's asking you about the clarity of the potential waiver in the manual. And you said, oh, but this was not written by the board. There's not a decision. Don't we also have a sort of theories of waiver that can occur based on agency action agents? So fine, we don't have the board making the determination, but surely the employees are agents of the WMATA. And if the employees are saying in official publications, we say sue us under these circumstances, wouldn't agency theory then allow us to conclude that that was at least an implied waiver, or that they were attempting to waive under those circumstances?
Well, I think for a large organization like WMATA, that's hard to apply. I do think that's why the rule is that it must be in statutory text. So you didn't find a situation where all three jurisdictions are going to be bound by what a WMATA representative puts out. It's also, and I'm glad Judge Sentelle raised the issue of clear and unequivocal. If you look at these three statements, they are not clear and unequivocal waiver. They are, even if you put aside this issue that it must be in statutory text, you don't have a clear and unequivocal waiver. The documents that my friend on the other side has put before the court are documents that are very similar to Section 81. It just says you go to the federal courts in the three jurisdictions. And as a matter of fact, Section 81 says all actions, and these three documents say for procurement or protest action. So it's a way for for Schindler to be able to argue that this is somehow different and outside of the compact. But because it needs to be in statutory text and because it needs to be clear and unequivocal, it has not reached that level here. It is not clear. Nowhere in those documents does it say, and WMATA agrees to waive its limited waiver for protest decisions or procurement decisions. All it says is if you have a case, you need to go to the court, but it doesn't somehow rule out Section 80.
All right. Thank you. Mr. Bartolomucci, why don't you take 2 minutes?
Thank you, Your Honor. I probably won't need all of that time.
Okay.
Couple quick points. Number one, my friend is wrong about the assertion that a waiver must be in statutory text. FAA versus Cooper is a case about the sovereign immunity of the US government. As to the US government, a waiver must be in statutory text, but that is not the rule that applies to waivers of state sovereign immunity. I've addressed this in my reply brief, and I'll refer you to that. And I will also point out in Unsuck DC Metro, I think that disputes his argument. There's no statute that says sovereign immunity is waived as to FOIA-like HARP claims. WMATA just did it on its own.
Mr. Bartolomucci, though, aren't you asking us to make new law in light of how this 80 and 81 has traditionally been construed? I mean, I hear that what Mr. Barnes is saying as consistent with my understanding of what this court has and others and the district judges, et cetera, have generally said about the scope of the immunity that WMATA has. So it seems quite novel to suddenly say, you know what, 80 and 81 are just talking about torts and contracts, but it doesn't mean that WMATA can't be sued for anything else as long as it waives its immunity.
Judge Jackson, you're not making new law, you're applying Barber, this court's decision in Barber, which all the cases that my friend cites are contract and tort cases. Barber is a different kind of case, and I don't think it even stops to talk about Section 80 because it didn't matter. Barber says that a clear declaration is sufficient to waive state sovereign immunity, including WMATA's immunity, and it found waiver in that case. And here, I think the waiver is clear. The PPM says federal district courts, quote, have jurisdiction over court actions concerning protest decisions, end quote. What could be clearer?
What about Mr. Barnes' point that as clear as that may be, it comes from an employee and not the board?
Well, I think I agree with your agency point. I think they're bound by their PPM, by their solicitation in this case, by their final decision. These are all actions of WMATA, and they bind WMATA. Mr. Barnes has not cited a single case for the proposition that only the WMATA board can affect a waiver. That's something that, as far as I can tell, they've invented in this case, and they've got no authority to support it.
All right. Thank you, gentlemen. Madam Clerk, if you'd call the last case.
Case number 20-1104 et al. Louisiana Public Service Commission petitioner versus Federal Energy Regulatory Commission. Mr. Fontham for the petitioner, Ms. Banta for the respondent.
Mr. Fontham, good morning.
Good morning, Your Honor, and may it please the court. I'm Mike Fontham. I represent the Louisiana Public Service Commission. This case is controlled by the court's decision in number 17-1251. There are two holdings in that case that are controlling and dispositive here, and that cut the foundation out of my opponent's arguments. The first was not covered, and I apologize for this, in my August letter. The second was, but I will speak of the one that was omitted first. In that case, Energy was arguing that an operating company could include an off-system sale in its load. And that had not been done for this case purposes with regard to the Grand Gulf sales in 2000. So that's what keeps it out of the case. But it was for a different purpose that was argued in 1251. The court said, no, you're wrong. FERC held, and this is in FERC's opinion, 521 at paragraphs 128, 29, that the violation was not a violation of 3003A. It was a violation of 30.04. And the court affirmed FERC's ruling that 3303A was ambiguous. And it said, this is on page 5 at the top of their memorandum, finding section 30.03 to be ambiguous, it determined that the opportunity sales were best understood as sales to others under section 30.04. This meant that the opportunity sales should have been deemed to have been fulfilled with the most expensive energy on the energy system.
I don't want to, your time is limited, and I do want to get to this. I'm concerned about whether we have jurisdiction. Now, you laid out in your supplemental brief the elements of standing, but you didn't lay them out very fully. Before you listed briefly that there has to be injury caused by the act of the defendant and remediable in the action. However, it's not just injury, it's injury personal to the plaintiff. What is the injury upon which you rely to the commission?
I'd rely on the injury to ratepayers.
No. Ratepayers are not the plaintiff here. You are the commission. What is the injury to the commission that gives you standing?
Under the Federal Power Act, Your Honor, we are the appointed representative of the ratepayer. The way that we are allowed to make a complaint specifically under the Federal Power Act, and we are allowed to pursue judicial review. Now, in Baton Rouge, the commission offices and the commission offices throughout Louisiana all had to pay these higher rates, the ones that are being served by Energy Louisiana.
That's not.
So there is an injury there, but I don't understand, and I think it would be out of step with every case. And I've had cases here at the DC Circuit in which our standing was exactly that and nothing other.
We have said, though, that if jurisdiction is not expressly decided in a prior case, that case does not bind the future decision on the question of jurisdiction. Now, what you see about the ratepayer seems to smack of parents patria standing, which is very limited when you talk about its availability to a state as against the federal government. If you look at Massachusetts versus EPA, that's pretty well written out of the possibilities for a state. And I'm going to not distinguish between a state and a state agency for a moment, but that's pretty well written out in the Massachusetts v. EPA. So do you have an injury to the commission itself that gives you Article 3 standing?
Well, I explained to you what the injury to the commission itself is, paying higher rates.
The commission's not paying higher rates, is it? The ratepayers are paying higher rates. The ratepayers are paying higher rates.
It has offices around Louisiana. It's a ratepayer.
Is that in the record? Is that in the record that you're appearing as a ratepayer in this?
No, Your Honor. We did not appear as a ratepayer. We appeared pursuant to Section 825 of the Federal Power Act.
Give me the language upon which you're relying from 825. Read that language.
I cited it. We cited
Read that language to me if you have it there, counsel. If you don't have it, just tell me you don't have it. But quote it as close as you can.
I can tell you what it says. It says that any state commission may file a complaint concerning anything done wrong under the Federal Power Act and 825L, I believe it is, which the court uses all the time with regard to jurisdiction. It says that a state commission can intervene on behalf, or can intervene in any FERC proceeding. And it says that a state commission specifically can appeal. Okay. And in 1251, we were appealing and we were found to have standing. It wasn't questioned, but we were found to have standing and the court dealt with our appeal.
Did you argue that this way in your brief?
In the brief
Yeah.
on standing that we just
Yeah.
filed?
Mhm.
Yes, of course. I mean,
Okay.
I argued that, we stand in the shoes of the ratepayer under the Federal
The
Power
problem
Act.
with that
because-
is it sounds to me like parents spectrum is standing and the Supreme
Well,
Court.
how would the
and the
ratepayers
Supreme
ever
Court
get
and the
represented?
Commonwealth of Massachusetts, the EPA, tells us that that's not available to states. And I did find it confusing that your briefs go back and forth between Commission and Louisiana, but you're appearing as the Commission, I think, not as the state, right?
We're appearing as the commission, but, we're under the state constitution, we are the regulator.
Okay.
And it's a plenary grant of power in Article 4, Section 21 of the Louisiana Constitution. So we have the equivalent status to the legislature
Mr.
or
Fontaine,
the commission
with Judge Sentelle's permission, can I just ask you another question?
I'm
Uh,
through. Go ahead. I won't have any
Okay.
more.
Thank you. So you were starting off talking about sort of the original decision about whether these were opportunity sales or joint sales, I think. And
Yes, Your Honor.
I guess what I'm trying to understand is whether your argument is that FERC didn't say enough about the conclusion it made in this regard, or whether there's not sufficient record evidence to support the change. I understand that originally it was characterized, the Grand Gulf sales were characterized as opportunity sales, which you think was the correct way to refer to them and to address them. And then during phase 3, they got characterized as joint sales, and that I understood to be part of what you are objecting to. But I guess I need to figure out and understand the basis of your objection. Are you saying that FERC they didn't say enough about why they believed that they were joint sales, or the record doesn't support that conclusion, or both?
It's both, Your Honor. That's the other ruling in the other case. I mean, FERC defined the opportunity sales in Opinion 521, and it included these sales based on Energy's testimony and representations. And then it ruled that the opportunity sales violated the system agreement. And the court already held that was a final decision. The only thing left was compliance and this, very discreet issue regarding the bandwidth, which didn't come into existence until 2005. It doesn't apply have any relevance whatsoever to the liability.
But was there
So that's one thing.
But was the original finding really a sort of litigated, disputed question of the nature of these sales, or they just put them all in the 2000 to 2009 basket without really focusing?
Well, it was a litigated issue in this sense. Energy was arguing that an operating company can make sales and that it can include it in its load, regardless. And, no matter what, it can pretend it's a native load customer, basically. So they included these sales. We had asked for them to identify individual operating company sales, not joint account sales. That's on page 1626 of the appendix.
Right, but then they didn't they eventually say, okay, so we went back over this in the damages phase and we made a mistake. We included things that we shouldn't have included. We're now presenting testimony that those things didn't count, and the FERC agreed and took them out. So what was wrong with the FERC's, other than the fact that it had originally included them, which I understand, but can it change its mind if there's evidence in the record to support the fact that that was a mistake?
Not in the compliance proceeding. They had ruled, and this is why it's really important, that 3004 was violated. It should have been the most expensive energy. That applies to either one, joint account sales or individual sales. It doesn't, there's no distinction there. And that's what the court said, you get the most expensive energy. But when they got to phase 3, and I don't know what came over FERC, except Energy was making the argument. Energy says, oh no, you ruled that it was 3003A that was the violation, and we didn't include these sales in Energy Arkansas's load, and therefore you should exclude them. So they based their argument on something that has now been ruled by this court in a final decision was not true. And FERC bought it for some reason. And, you know, the fact that there was an additional violation does not undo the fact that it violated 30.04 to take Grand Gulf, which is one of the lowest cost resources on the system, and assign it to an opportunity sale, no matter what you call it, because it's supposed to be the most expensive energy. And, you know, the ratepayers were paying for this capacity. This system worked in such a way that everybody paid for Grand Gulf. It was allocated among the companies, and the retained share was included at full cost in the allocations. And, you know, they took energy that was supposed to go to the ratepayers, and they sold it off system because they could get a benefit for the shareholder. And they bought power to replace it, or else they generated power at this, you know, $80 or so a megawatt hour when Grand Gulf cost 10. And they loaded that right into the fuel clauses, so the ratepayers had to pay.
All right, so can
But
I ask you another,
trying to-
I'm mindful of the time. I'm trying to understand, in the wake of the settlement, which
Yes, ma'am.
ultimately the FERC decides precludes you from making assertions concerning the impropriety of the calculations with respect to Grand Gulf. Why is it that you think that you should be able to litigate this now? We thought everything was wound down, the settlement happened. First of all, why did it take so long for you all to file a petition concerning the Grand Gulf sales? Why wasn't it not until 2019 that that happened? And the settlement intervened, didn't it?
Yes, it did, Your Honor, but let me try to clarify this. We're mainly arguing about the 565 decision. We're not mainly arguing about our complaint. We only filed that complaint because FERC said, go file a new complaint if you want to do something about this.
Okay.
But in regard to your earlier question, you've got a final ruling now that FERC tried to change in this compliance proceeding. That's a collateral attack. They always dismiss that. And you've also got the fact that they say that it was allocated as a joint account sale. That's absolutely false. Now, they didn't cite any evidence. There was tons of evidence in the record that it was allocated energy from the Grand Gulf unit. It was not allocated energy from the, you know, incremental cost system dispatch that normally covers joint account sales. So, you know, it's just a false statement, and there is absolutely nothing in the record to support it. And FERC just, you know, they refused to comment on our evidence. Nobody denied what we said. It was unrebutted. And they just, you know, they just blew it off as if it wasn't there. We are not, I think they said something like, we are not convinced or persuaded by Louisiana's evidence. Well, that's not addressing the issue, as Judge Sentelle said in the, you know, the first big rough equalization case. That's a conclusion.
All right, Judge
That's
Jackson,
not a
has he
reason.
answered your question?
Yes, thank you.
All right, we'll hear from Ms. Banta.
Could you start with where counsel left off on the
Yes,
statement that he's addressing there?
absolutely. Yes, Your Honor. Carol Banter for the commission. I would like to start by giving you a number of record citations for the commission's, supporting the commission's finding that these Grand Gulf sales were treated as joint account sales. First of all, the commission found that in opinion 565 at paragraphs 102 and 104, and contrary to what you just heard, the commission did rely on evidence. It specifically cited its own trial staff, which if you look at paragraphs 97 and 98 of opinion 565, that's the recap. And I do apologize that we did not include the trial staff's brief on exceptions in the joint appendix. I would be happy to provide that to the court. It is record material. We did not designate it for the joint appendix. Trial staff in its brief on exceptions cited both the trial staff witness Salmon's testimony, which we did include in the joint appendix and in our brief. That's at JA 904 and 909 in particular. The trial staff in its brief on exceptions also cited the Entergy testimony or a data response, I forget which, that had been put into evidence. So it was in the record saying these were treated as joint account sales from the start. But I'd also like to look at, to point to places where the Louisiana Commission itself has repeatedly agreed with that. In Mr. Barron's rebuttal testimony at Joint Appendix 1217, and also I believe at 1226, he stated that Entergy began including the Grand Gulf sales in load under section 30.03 in October 2000, meaning that it was not before. And I'd like to come back to the 30.03 point, but I'd like to also in Louisiana's phase 3 rehearing request at JA 1378, and in its 2019 complaint at JA 1409, which the commission cited in its rehearing order at paragraph 28, note 63. Once Entergy put in phase 3, as the commission said, it's the first time that the entire 10-year span of off-system sales was examined, and they went back to rerun the intra-system bill, and it involved a great deal of examination and recoding transactions to figure it out 10 years later. And Entergy came forward and said, the first 9 months of 2000, these off-system sales were treated as joint account sales. That means they're not made on Entergy Arkansas's behalf. They're made on behalf of the system with revenue sharing among the operating companies.
Ms. Banta, can you address Mr. Farnham's contention that the FERC had previously already said something different with respect to whether or not those sales were joint account sales and whether or not they violated 30.004?
Well, to be clear,
I'm struggling to understand the argument that he's making, and I'm trying to see what your perspective of it is.
right. And I'd like to give there are two parts to that answer. I want to emphasize, looking at opinion 521, as well as this court's decision affirming it in all respects, the violation in the opportunity sales, which were off-system sales made by Entergy Arkansas for its own account, not sharing among the companies, but for its own account. Entergy was including those off-system customers in its loads, in its load shape under 30.03, instead of treating them as sales to others. It made the argument, Entergy did, which did not prevail before the commission or before this court, that those sales were part of its requirements and should be treated as part of loads under 30.03. The violation in 521 is the commission said that was the violation. Those are not loads. The way we read this, although we know it's ambiguous, because they are sales to others, they should be treated under 30.04. But let's be clear that there are two kinds of sales that can happen under 30.04. They're both sales to others. They're both sales off the Entergy system. But one kind of sale is made for the sole account of the company making the sale. That was one of the disputes in opinion 521, was even whether Entergy had the right to do that. And there is language in section 4.05 of the system agreement that says that joint account sales are sales off the system for which a company does not want to take sole responsibility. And the commission said, by negative implication, there must be sales for which the individual company can take sole responsibility. So it's those sole responsibility sales that are the definition of opportunity sales. And I would point you, for one thing, to the language in 521 that petitioner themselves, Louisiana has emphasized in paragraph 2, this is on JA 696 in footnote 5. And this is the broad definition of what are the sales that are at issue here? What are the transactions that are at issue? The capitalized phrase opportunity sales refers to the disputed off-system sales of energy by Entergy Arkansas. And we skip forward, for its shareholders' behalf. That means not joint account sales, because there was never any dispute that joint account sales were permissible under 4.05 of the system agreement. The entire dispute was, number one, Louisiana took the position that Entergy Arkansas had no right to make these sales at all. Opportunity sales. It unequivocally had the right to make joint account sales. The dispute was that it had no right to make opportunity sales, and that when it did make opportunity sales, it violated the system agreement by including them in its customer base, its loads, under 30.03. And that was the violation the commission found. It found no violation of 4.05. It found no violation of a couple other provisions that were argued about. The violation in opinion 521 was including off-system customer sales in the loads instead of treating them differently as sales to others.
All right, so in that case, what you're saying is they didn't really make a decision earlier that they contradicted with their determination that it was that these should be treated as joint account sales,
right,
in phase 3.
Right, and let me make it even clearer. The 3-phase litigation, the commission looked at, and there were the other issues that came up about bandwidth adjustments and so on. But the commission, and we did this in our brief, we presented it this way to the court, and the orders presented this way. Phase 1 was liability. Is there a violation of the system agreement? Does it warrant awarding damages? Phase 2, methodology. In phase 2, the parties only litigated over 3 test years. And I always forget which years they are. They are not 2000. I believe it was 2003, 2006, and the other one was either 4 or 5. I don't remember which, to litigate the methodology. And so the commission says in phase 3, in opinion 565, that this phase is the first phase where the entire 10 years of transactions were on the table. The liability is there. We've already decided the liability. Opportunity sales that were put into load in section 30.03 are the liability. And what we have in the evidence I cited earlier, including Louisiana's own rebuttal testimony, they didn't dispute. They may have disputed how they did not dispute that those sales had been treated as joint account sales at that point. And even if they had disputed, the commission still had sufficient evidence in the testimony of trial staff witness Salmon and in Entergy's testimony that it put in, that is what had happened with those first 9 months. The commission had sufficient evidence to make that finding as to those 9 months for the first time. And it was finding that they were never of the sort of violation that we found in phase 1 to begin with. Therefore, they are not part of the damages to be calculated in phase 3.
And they said, the commission says this, and fully, because Mr. Fontham suggests that there's also an explanation problem.
The commission, looking at 565 in particular, and in paragraph 106, which is on JA 48, the total damages calculation for the entire period of the opportunity sales was not at issue in this proceeding until this phase 3. And but previously in paragraph 103 on the page before, that's where the commission makes the finding that the Grand Gulf sales at issue, these 9 months, were not improperly allocated under section 30.03. Again, that's the opinion 521 violation. And that's why the commission went on to say, I believe in the rehearing order, that, in paragraph 46 on JA 118 and 119, this is not a collateral attack on opinion 521. And it cites back to what I just read you from paragraph 106 in the first order, that the total damages calculation for the entire period was not at issue until now.
So is it FERC's position that something about the settlement agreement precludes they're making claims of this nature, or is the settlement agreement issue only with respect to the new complaint?
I believe it's only with respect to the new complaint. The litigation, the out of scope finding in phase 3, whatever they want to argue about the commission being right or wrong about the scope finding, that's all part of the first proceeding that continued forward.
That continued, so it has nothing to do with the settlement.
Right. I would like to make one point. There was nothing, first of all, 2 points. The court, of course, upheld the phase 1, 2, and 3 orders in all respects, but in particular, its discretion as to scope findings. And in particular, the Arkansas Commission had raised a different issue that the commission kept saying, we're not deciding here because it's beyond the scope. And the court very strongly affirmed that and that's not unusual in these cases. The phase 1, 2, and 3 case first arose in an earlier case where some of these off-system sales were discovered. And the commission said, that's not really an issue here. And the court said, whatever the commission said about that was dicta, go file a complaint. I could cite a number of cases where that's happened. There have been a number of offshoots of other cases. Some issue comes up, the commission says that's not within the scope of this case. Louisiana goes and files a separate complaint. So that was something that happened pretty frequently under system agreement litigation.
All right. Thank you. Mr. Farnham, take 2 minutes.
Thank you, Your Honor. My opponent just said that Energy Arkansas made joint account sales, and these are joint account sales made by Energy Arkansas. That can't be done. The system has to make a joint account sale. I would like to address Judge Jackson's question, and there is perhaps, you have to understand what's going on here to really get it, I think, just on the basis of the briefs. When they first started doing this, they did distribute some margins to the other companies, but they still sourced the sales out of Grand Gulf. In other words, they did not find the most expensive energy on the system, as they're supposed to do, for a joint account sale. Then, rather than using the fuel cost of Grand Gulf, which is about $5 to $10 a megawatt hour, they paid Arkansas, which didn't generate the energy in the first place, they paid Arkansas avoided cost, which was more like $70 or $80 a megawatt hour, totally fictitious. And they then had a tiny bit of margins that they distributed to the other companies. Later, they just they got rid of that, extra bureaucracy, and they started allocating the sales directly into Arkansas's load. But in 1251, the court doesn't say anything about it was a joint account sale or it wasn't a joint account sale. It says the violation is allocating something besides the most expensive energy on the system to either kind of sale. There is no dispute that they didn't do that.
I'm
They
sorry, what
allocated
opinion,
Grand
there's so many numbers.
Yeah.
You say the court said
the earlier
that
decision of the court that came out in June,
of the
1251.
court, not the FERC, the court.
That's court affirming FERC on finding the violation to be under 30.04 by the fact that they didn't allocate the correct energy. Now, in a sense, they were called joint account sales, although Energy had to know this.
Oops.
Wait, Energy had to know this when they answered those data requests, because they had to rig the ISB to do what they did. They had to rig it in several ways, paying avoided cost and putting the Grand Gulf energy instead of the system incremental cost. And yet they represented that it was an Energy Arkansas sale because their position in the case was, oh, an individual operating company can make a sale. Then they change their mind in phase 3 and say, oh, you know, this violation of 3003A when FERC said it was 3004. You know, it's, to me, it's dumbfounding, but that's what happened.
All right,
And
Judge
Judge
Jackson.
Sentelle, you might want to take a look at 825 LA, which is the application for rehearing and the appeal provision. It specifically says any state municipality or state commission aggrieved by an order. We paid higher rates just like the ratepayers.
All right. Thank you. Madam Clerk, would you give us a adjournment, please?
This honorable court is now adjourned until Friday, September 24th at 9:30 a.m.